Welcome to this video on the application of Rylands and Fletcher torts. This is focused on A-level application. Now the first thing we need to do is identify and define the tort. So we know this is defined as whether a defendant accumulates on this land a dangerous thing in the course of non-natural use of the land and the thing escapes and causes damage. So we shouldn't be too bogged down in defining the law. We want to focus on our explanation for AO1 and our application for AO2 and 3, really, the extended application. So we should focus on explaining and applying. So to explain the law, a defendant is liable then in Rylands and Fletcher torts if on his land he accumulates a dangerous thing that in the course of non-natural use of that land and the thing escapes and causes reasonably foreseeable damage. So that's an overview. And of course the two key cases we can use are Rylands and Fletcher and Transco as illustrated on the screen, but also in the explanation video. So we're going to deal with each of these elements in turn then. So the first thing is that the defendant brought something onto his land, and this means that it must voluntarily bring something onto his land and accumulate the substance which actually escaped. Now this does cover artificial accumulation of material, but not non-natural use, not natural accumulation such as a lake or a naturally occurring body of water. Now the fact that something naturally is on the land as escape will not suffice for liability under this tort, but there may be liability in either public or private nuisance. Now it's not essential then that the thing is brought onto the land by an owner or occupier, but of course because they have control of the land they should be preventing any potential harm. You can then support your discussion of the key facts with some key cases. So we have Ellison and Ministry of Defence, Jars and Walker on Leakey National Trust, and of course Charing Cross Electric Supply and Hydraulic Power Company. So you can use them to support the key points, but of course all of this is explained in the explanation video. We're focusing on application. So what we need to do is ask, what if anything did the defendant bring onto his land? So if it was not the defendant, liability can still exist. We need to identify any particular scenario. And of course, did the thing accumulate artificially? So what we're saying, we artificially, this means he creates something like in Rylands and Fletcher, creating a reservoir for the water that is artificial, but accumulation of rainwater would not be the same thing. And by way of recap, we need to consider the fact the defendant made a non-natural use of the land. So a recap is a non-natural use does not mean a use which is artificial or man-made, but rather something which is not commonplace. So a useful guide in deciding whether the risk was created by a non-natural user of land is to ask whether the damage was something against which the occupier could reasonably be expected to have insured himself. So if it's sort of foreseeable, then it's non-natural. Again, you can support this with some key cases: Rickards and Lothian, Mason and Levy Autopart, or Cambridge Water and Eastern Counties Leather. But we are focused on the application, so the questions we need to ask and answer for the AO2 and AO3 marks are: was the defendant using the land in a non-natural way? So explain exactly in the scenario how this defendant is using the land. So was the land used in a way which is not commonplace? Identify why. And if it isn't immediately obvious, ask should or could the person have insured himself against this risk. If you would take out insurance for that kind of thing, or it possibly exists, then it's foreseeable, and therefore we could consider this non-natural use of land. The third element then is the thing was something likely to do mischief if it escapes. So in scenarios you've seen things like oil, water, obvious things which could escape and cause some damage, but we need to be more careful and obviously go back over the explanation PowerPoint if you're unsure about what can constitute something likely to do mischief. But the thing itself doesn't need to be dangerous, but it must likely to cause damage should an escape occur. So in this situation you could identify that the defendant keeps it at his peril, so it's in his mind that it could cause mischief, and that just means damage, doesn't it, in this context? And anything can be regarded as dangerous in particular circumstances. So courts have actually avoided giving a definition of dangerous and have decided each case on its own particular facts. And of course, you can gain those extra AO3 marks by analysing what could and could not be considered something likely to do mischief. And again, we've got some key cases here to support: Rylands and Fletcher, Crowhurst, Musgrove, Shiffin, Hale, Hillier, You can obviously pause this video if you wish to take the notes of the cases down, but of course most of these cases are explored in the explanation video. So to apply this, we need to consider what is the thing being stored, and of course you need to list in what possible ways can this thing cause damage. So if it's water, for example, an obvious example is flooding, but it could cause some other damage, for example damage to electrical equipment, for example. So it's not just about the way it does in the scenario, but you're going to get better marks by identifying why the thing is dangerous, because this thing could cause several different types of damage. So could it be said that it was likely to cause damage? You need to conclude to disregard. And the fourth element in terms of the main aspects of the tort then, the thing did escape and cause reasonably foreseeable damage. Well, there must be an escape of the dangerous substance from the land, so the thing must move from land controlled by the defendant to land controlled by the claimant. An escape for the purposes of Rylands and Fletcher means escape from a place where the defendant has occupation or control over to a place, as we just described there, occupied by the claimant. Now the thing itself doesn't need to be escape, but of course if the thing escapes itself, then of course you're more likely to have a successful claim. We've seen cases where fire has escaped, and in that context there have been claims successful and claims not successful with respect to fire. So usually the thing itself should escape, but it's not always the case. Now only damage which is reasonably foreseeable is recoverable, so it's quite consistent with the rest of tort law in that the normal rules on remoteness of damage apply here. Again, some key cases to support: Reed and Lyons, British Celanese and Hunt, Miles and Forest Rock Granite, Cambridge Water and Eastern Counties Leather, and Transco and Stockport. The facts are on the screen should you wish to look over them, but they are of course dealt with in the other video as explained in the law. So for application, we've identified the thing which is likely to cause mischief. We now ask, did this thing actually escape from the land? So did the thing move from the defendant's claim to the land to the claimant's land? And of course what we've got is water here, oil would go, fire would spread. All this thing needs to move from one place to another. So again, we need to consider, is the damage foreseeable or is it too remote? So it might be the case that in your scenario there's several types of damage. Only foreseeable damages can actually be recoverable. So once we made a decision as to whether all four of the elements from the Rylands and Fletcher tort exist, we then need to consider any possible defences. Now, if there's a long form question, a 10-mark question or part of the 30-mark questions, then of course you need to make sure any potential defences are dealt with. Two you will have covered already in your earlier studies of negligence, for example, of valenti and contributory negligence. So valenti is the idea of consent. Has the person consented in some way to the thing being stored? If they have, identify this, raise it as a possible defence and conclude as to whether you think this would remove liability. With contributory negligence, this is obviously reduces damages. It's not a full defence in the same way valenti is, but of course we need to ensure that we identify any factors where the claimant is possibly to blame, or at least partially to blame, and you would suggest that damages will be reduced. Now remember, this can be up to 100%. And then three specific defences in the middle there: act of a stranger, act of God, or statutory authority, are specific to nuisance offences. So act of a stranger is a simple one, in which if somebody else comes on to your land and does a thing which you have no control over, then you may not be liable. So this could be, for example, a trespasser coming onto your land and turning taps on, and if flooding next door or something. Now there are other reasons that wouldn't satisfy, but act of a stranger certainly is where you can't explain what happened. So act of God, this is usually a weather event which is unforeseeable, so a storm, thunderstorm for example. And of course this may break the banks of a river, and of course if you store any liquid solution on your land and it sort of floods, of course this would be applicable here if the weather event was unforeseeable. Now statutory authority, if the person has permission to keep hold or store or accumulate this kind of thing on the premises, then there may not be liability if all the elements are not satisfied, or even if they are to a degree. So statutory authority, and of course this extends to local planning permission also. Now we do then need to conclude if any defences are applicable, they may reduce liability or remove liability entirely, and if so, then there will be a not liable outcome. But we do need to consider then if there is an outcome, then what are the potential remedies? So with Rylands and Fletcher torts, that would usually be damages to fix the wrong, to right the wrong, because of course the purposes of damage in tort law, or the purposes of damages in tort law, are to put the claimant back in the position they would have been in had the event not occurred. And that's the same for negligence, it's the same for occupiers liability, it's the same here too. So we're going to run through a worked example, and this is an old exam question. And what we're going to do is see how we'd explain the law and apply the law, and of course look to how much of each we should be covering, and indeed look at the structure as well. So we have here Cheap Cells Supermarket as a recycling centre on this land. This includes a can recycling unit and a cooking oil disposable tank, which members of the public in the supermarket cafe can use. Now Harriet owns the neighbouring farm. During a terrible storm, the top of the can unit breaks loose. Harriet is struck by a can which is blown out of the unit as she tries to protect her prize-winning pumpkins. She suffers a cut face and the top of the can unit smashes the door of a greenhouse. Now the heavy rainfall fills the oil disposal tank to the top. Oil then leaks into Harriet's garden, contaminating the soil and destroying the pumpkin crop. Now it costs Harriet £5,000 to clean up the contaminated soil, and she loses an estimated £1,000 profit which she would have made on the crop. So what we're doing here is advising whether Harriet will be able to bring any successful claims against Cheap Cells under the principles set out in the tort of Rylands and Fletcher. So the first thing we need to do is identify. Now you are told in this question what to do, but of course if this was part of a larger question or it was an open-ended question, then of course you would need to identify what the issue is. So Harriet here could claim against under the tort law rule in Rylands and Fletcher against Cheap Cells as they have ownership of the premises from which the damage is coming. So if you're following the IJAC structure, you may need to define the law as we dealt with earlier on in this video. Now you don't need to list every single element if you're going to deal with every element anyway. Of course, if you have a situation where it's a shorter answer question and maybe only one or two of the elements need actually to be discussed because maybe it's already outlined what the conclusion is, then you might wish to give a definition. But for this one, you wouldn't necessarily need to. So an overall definition would be fine, but you certainly don't need to give the 4 key ingredients for the tort. You may do if you want, if you're a completist, but in honesty, if you're going to deal with them anyway, you don't need to be putting them in here. So the bulk of what you're going to be doing here then is explaining and applying the law. What you'll see here over the next few slides is that we're going to explain in blue and apply in red, just so you can see the difference between the two. Case law will be in either. It really doesn't matter so long as you're proving your point and you're triangulating your points using cases. You should be hitting those top bands. Now, by no means is this perfect. This is just an example. I'm pretty sure you can do better yourself. So here then we got the defendant must own or have interest or some degree of control of the land. So we're identifying who is going to be the defendant. And we've got in red, which presumably is satisfied here, as Cheap Cells has a recycling centre on its land, suggesting it belongs to them. At the very least, they will have control over it. So we do have that element satisfied very quickly. You can see it's sort of 50-50 split in terms of detail. Now there must be an accumulation or storage of the items, so which means that things must not be naturally occurring, such as weed, for example, as in Giles and Walker. Now here the cans, the top of the unit and oil have been brought onto the land by customers or users of the recycling centre, so there is an accumulation here and a storage. Now the thing brought onto the land must be dangerous. This means if it escaped, it could cause foreseeable damage, as outlined in Hale and Jennings with the chairplane ride. It doesn't have to be inherently dangerous though, so water is not necessarily dangerous if it's on your premises. Oil is not necessarily dangerous, but of course in certain circumstances both of those items could be. Now in this case, cans would not usually be considered to be dangerous, but the manner in which they caused damage suggests they were. Now following British, Celanese and Hunt, where foil was considered dangerous, cans probably would be too. Now the top of the unit and the oil would almost certainly be considered dangerous. So we can see here we're starting to get more application because the issues are more contentious. Now, the concept of non-natural use of land then is perhaps the most contentious of all the elements for this tort. It was defined in Ricards and Lothian to mean a special use of land, but has come to mean unreasonable use of land now. Sometimes, as outlined in Cambridge Water and Eastern Counties Leather, a use can be non-natural even if it's a public benefit. And so what we got there in blue, there is a bit of analysis here too, so the AO3 could come through in your explanation as well, as it has done here. But the application, this concept would be applicable here, as although the recycling centres provided a public benefit, the court may still feel it's hazardous and therefore non-natural use of land, considering the damage to the top of the can unit and oil caused. So finally, the thing must escape and cause foreseeable damage to an adjoining property, as outlined in Rylands, where bombs exploded on the premises and therefore didn't escape, and of course there was no liability. Now, this is probably the most contentious issue. It's quite straightforward, but of course need to say how exactly it happened in this scenario. And we've done this by saying a can was blown out of the unit on Harriet's land and therefore has escaped. The top of the unit is also blown, such was the force of the weather. In addition, the oil leaked into Harriet's garden again, has escaped. The main question here is whether the damage is foreseeable. Now, Harriet cannot claim for personal injury following Transco, which she moved away from the decision Hale and Jennings, but Harriet could claim for the destruction of the greenhouse, but perhaps this could be too remote, as this kind of damage might be unforeseeable. With respect to the oil destroying the crops, this could be considered foreseeable, as they set up a recycling centre next to land which is a farm. Now, the nature of the farm is that crops will usually be grown or animals will be grazed, and this will be obvious to the supermarket, so therefore foreseeable. So we've got an idea then. There are several different types of damage, some which will be, some which will not be foreseeable, and maybe this is the way it could come up in your exam, and this is the thing you need to analyse most. So now all four elements are potentially satisfied for this tort. We need to consider any defences. So as with any tort then, there are defences potentially available to the defendant. These range from consent to an act of God for these type, the Rylands and Fletcher torts. Now here, the defence of an act of God may be available as there is a terrible storm. Now, as this may be classed as weather conditions which no human foresight can provide against. The defence was successfully used in Nichols and Marsland where there were freak thunderstorms. However, this was in 1876 when it would have been more difficult to predict the weather. It may be easier to do so now using apps and websites, so may be more difficult to raise the defence. Now, in addition, one not mentioned on here is the fact that it's a recycling centre, and of course there might be statutory authority for that. So we do need to consider all possible defences here. Now, in conclusion then, it seems Harriet may have a successful claim under the rule in Rylands and Fletcher, but not for aspects of the claim. Now, she cannot claim for the personal injury. She may not be able to claim for the damage to the greenhouse, as it may be considered too remote, but she would probably be successful for damage to the garden and the crops from the oil. To this end, she could claim around £6,000 identified in damages, so £5,000 for the garden and £1,000 for the consequential loss of profit. Now, essentially, this is what the pumpkins which were destroyed were worth. Now, all the remedies for this tort are usually given to replace or repair the property damages or destroyed. Now, this is not a perfect example by any stretch of the imagination, but it is a guide as to what you should be putting in the answer for Rylands and Fletcher torts. If you've identified any other defences or any other discussion points, pop them in. Okay, this is a sample example of what you might do for a particular question. So I do hope this video was useful, and good luck in applying the law to any scenario. Thanks for watching.